Okay, it is Wednesday, September the 4th. It's 8:30 p.m. Central Standard Time, and I am Professor Richard Wright. Welcome to Week 10. This is the final lecture for this course, and the quarter ends next week. So this is the final lecture, the very final lecture. And I hope that you guys have listened to the previous lectures. I know that in this course it doesn't require you for a grade to listen. However, though, I always encourage students. I said there are many mistakes that you make in your assignments that I know I cover in the lectures, and I can tell by the mistakes that they're not really followed, or you don't take the time to listen to them. So it's very important that you do so. So I'm going to go ahead and talk about the topic this week, share my screen, then dismiss. Okay, let's go to the course home. Those are the papers. Okay, you can see information here, and it tells you that the last lecture is today. You have lectures 1, 2, 4, 6, and 8 recordings here. And so now let's take a look at the announcement for this week. Juvenile offenders, the topic for this week. I previously sent you chapter 13 of your text, the PowerPoint. So you should have that to prepare for the week's lesson, as well as having done the reading. And then we're going to deal with the juvenile justice system, and how it works in a historical perspective, major cases, juvenile corrections vocabulary, and then we're going to adjourn. The discussion assignment is the role of the juvenile probation officer, which some of you are seeking to take a role in, and then your state's waiver process, and the quiz. And remember, as I've said before, that I recommend that you take the quiz at the end of the week, which the end of the week in this case is Sunday. All right. So let's go right to this week's viewing of the course calendar. And here it is. This shows you where we are right here. Your reading assignment was Monday. Your initial post was due on yesterday, 11:59 p.m. Central Standard Time. Your reply post due Saturday the 7th. Your quiz, time quiz, which I say it is a time quiz. And then your written assignment, which the rubric covers your state's waiver, which requires 2 pages. And then repeating the facts don't help satisfy the requirement. I'm more interested in your critical thinking. I say that all the time as I run your papers through Grammarly. And then next week, the final week, starts the 9th. And then your initial post will be due Tuesday the 10th for week 11. And then notice the course ends on the 13th. You have a written assignment and you have a final exam. And that will be due on the 13th, not the 14th, not the 15th. Any assignments that are submitted after 11:59 p.m. Central Standard on the 13th will be technically considered late and not accepted. I don't care how good it is. I will not even grade it because it will be submitted too late. So the course ends a week from Friday. Be aware of that, okay? If you look at the announcement, you'll see that when I show that to you at the end tonight. So your written assignment is your state's waiver process. You're supposed to look at your state's process for transferring juveniles to adult court, and two-page paper explain the options available in your state and the process that's used to accomplish this waiver to adult court, and include any statutes in your state and automatic transfers that are involved. Also mention that. And then that's a two-page paper, again, due Sunday the 8th. This is the rubric, which I encourage you to look at and conduct your research. And I always tell students, I say that I put your grade in based on, and then under this there's a section called feedback. And a lot of you don't pay attention to that. And when you look at that feedback section, it tells you what you did wrong, if you didn't. But it's very simple. If you just follow what it says in the rubric and make sure that it's done accordingly. Notice the page length, 2 pages. It's very quickly seen because it's right at the very end. And then your APA requirements, remember, citations in the body and references at the end. One of the common errors that many students make is that they don't provide citations in the body. You'll provide references, but guess what? Doesn't matter. You're still going to not get any points for that, because the APA requirement is very simple. It requires both. And we've been providing resources since the beginning of this course. Matter of fact, the school has so many different resources now. Those of you who have the app downloaded on your phone, whether it's Apple or Android, they have sessions that they have pushed out and promoted for you to be able to be aware of. The Library and Learning Center under the Resource tab has plenty of resources, as well as the course homepage. And then never use Wikipedia for a topic, for a reference or source. You also know that you must conduct research. Your textbook cannot be the sole source of your papers because you'll lose points. That's located on your course homepage. The other issue that people lose points on is not running their papers through Grammarly to make sure that you check for plagiarism. And if you're 25% and above, then you're going to get a hit. I look at it and read the papers very carefully. Also, you should be aware that the plagiarism check that I do for Grammarly can tell me exactly where you got the information from. And oftentimes, you don't give credit for that in your paper because of the fact that you want to try to use it as your own statement. But you've already seen the academic integrity video, and it's located in the resource tab as well as on the course homepage. And it explains the importance of citations and references. And so you get hit with those Grammarly hits, and they can cost you possible removal from the course and or dismissal from the school. So you got to make sure that you satisfy that. We're trying to create students who are good writers and who use proper form and write with integrity. That's what APA is all about. And so it's important that you satisfy the rubric. The rubric is there. And again, I repeat that if you want to find out where the information is that I put in your grade, comment about your grade, look in the feedback. Look in the feedback, okay? So that's the rubric. So let's go back. And you're going to see that it's not much more that you have to do. Your discussion, research the role and duties of juvenile probation officers, what they're supposed to do, what you believe is the most difficult part of the job, and then finally the quiz. The quiz is timed, and it's 10 minutes. So that tells you what? 1 minute for each question. And again, you agree to abide by the academic misconduct policy. In other words, that you should not be having materials in front of you. It's a closed book exam. And we're not there to proctor review, but the results do show up when we see that you get 2 questions in 10 minutes. That means then that you're looking for some material that you shouldn't be looking for. You should be reading the questions and thinking about the questions, and then submitting your answers. Okay? So now let's get into the content about what we're talking about, which is dealing with let's see, we go to week 10. I jumped to week 11. Let's go to, okay, I did the assignments for week 10. Okay, so now let's go back and let's look at the topic of what we're talking about today, and it's all about juvenile justice. So we're going to talk about these 3 things, and then I'm going to share with you week 11 information, and then we're going to adjourn. So the juvenile justice system goes back to England, when the king was the person who was chosen to look out for the children or for minors. And the concept of what we call parent patriarchy, which means that the system is set up to help youth. And so the king would protect the children. And today the juvenile courts act as parents patriarchy, or the parents, or sometimes in the place of them when there are behavior issues that take place. And you're going to discover that there's different language that's used which reflect the goal. The goal of juvenile justice system is directed towards rehabilitation and trying to salvage the juvenile, though it's just similar to the adult system, but the process doesn't begin with an indictment or a summons. It begins with what we call a petition, which makes it sound more civil. So it's really quasi-civil because of the fact that we don't really want to label individuals as criminals. You'll see that in a minute. So juveniles show you the difference between the two in terms of the justice system and the adult system, is that juveniles are taken into custody. Well, adults are too, but that's the whole process. You are not placed under arrest as a juvenile. However, when you are in custody, that means you can't go, and you know, of course, the Miranda rights apply to that. And juveniles have those rights. We'll be talking about that a little later on. But juveniles are taken into custody, and juveniles are detained, not jailed. They're put in detention centers. They're called juvenile detention centers, and then adjudicated, which means you're not found guilty, but you're adjudicated, which means the system is determined. It's generally a closed system, as you discover that the idea is to protect the juvenile from the public as much as possible. There are certain rights that you have in adult court that you don't have here. We'll go over those in a few minutes. And you are given a disposition, not a sentence. So when you are detained, you are given that disposition for a period of time based upon the offenses that you have committed. Now, we're going to talk a little bit later about the adult issues that have taken place because of the fact that many juveniles now have elevated themselves to the level where they're committing offenses or violating the law and committing crimes at the same level as adult offenders. And so we'll talk about that in terms of the waiver process at the conclusion of this section here. But right now, I want to tell you that when an individual is given a disposition, prior to that, there is, just like the adult have what they call a PSI, or pre-sentence investigation, and so juveniles have an investigation and report is ordered to determine what the disposition of the case will be. And what it does is it provides the background of that juvenile, the history of their contact with the system or lack of contact with the system as well. And the judge uses that to determine the sentence. Now, it is the judge alone who determines the sentence of the or the disposition, should I say, of the juvenile offender. And so the judge looks at the risks, the needs, what's necessary, what kind of programs are needed to help this juvenile. And juveniles also, similar to adults, report to when there's a disposition in the case and they're adjudicated. That means then that they've been found equal to what we have in adult court as being found guilty, and then the disposition takes place there. And so in those instances, there are programs and services that are necessary to help the youth. One of them, the major programs, is to help the youth with education. If there's some drug problems, then to help the juvenile with that. If there's alcohol problems, to help the juvenile with that. And so, as I said, the juveniles report to a PO, or probation officer, but the probation officer works more with the family to help the family to come back together. So the role of the juvenile probation officer is more like, I always say, a social worker or a caseworker. That's the way I put it. A little different from the adult system. And so the key is, again, to try to salvage that individual to keep them from reaching the level of adult offenses. Now, because of the fact that you and I both know that there are many, many juveniles now who are involved in very serious offenses that are pretty violent, a lot of shootings, you got carjacking, you got drug dealing, you've got all kinds of serious offenses, committing robberies and things like that, armed robberies. So what happens in many jurisdictions now, there is a waiver system. And what the waiver system is a system that's designed to allow that individual, based upon the offense, and it's very serious offenses, to be tried as an adult. And they are tried in an adult court. Now, once they are tried in adult court, then the whole process changes. And every state has some form of waiver process, but it has to be involved with a serious offense. So prison can be involved in those kinds of situations. Now, the one thing that we really hate to do is to place a juvenile in a facility or among adult prisoners, because what happens is they begin to, tutor, they become mentors, and they begin to teach young people how to be criminals, how to become criminals better than they were as juveniles. And basically, once they get to that stage, then they begin to stay in the adult system, even up until they turn a certain age. But then they, as adults, of course, you know, you're in the adult system. And so because of the violent nature that exists and the possible exploitation of adult offenders, prison is the last resort for individuals where they're sent. And, you know, it's quite clear that usually they have less time in terms of serving in facilities, and so they get out and then they again turn into adult criminals. And so oftentimes many states have intensive programs to try to help these kids and then place them in situations similar to adults under what we call house arrest or electric monitoring, you know, where they put the ankle bracelets on the individuals. So the key thing in the juvenile justice system is for you to be aware of the fact is that we try to help to give them a chance. You should be aware that the juvenile record is sealed after the person is an adult. However, what happens is they commit offenses similar to the juvenile, and they find themselves incarcerated as an adult, and then there is a criminal record. The probation officer, again, back to that again, is almost like I said, it's a social worker. I said it's a caseworker, someone who's there to try to help to get this juvenile on the right track and submit them, you know, get them going in a new direction in life to turn their ways around. Okay, and so that's pretty much the juvenile system. Again, it's a closed system. It's not open, and that the people who generally are allowed in there are the people who are the family members or that are involved with the case itself. The media generally is not allowed in there, and if they are, then they are allowed under special circumstances. And so, again, we're going to talk about certain perspectives and rights right now as we talk about in this section, tying in major legal cases that has shaped how the juvenile system operates. So let me activate this so that you can see it. So it involves here, this little thing here involves the history of juvenile justice going back to 1966, the famous Kent versus United States case, a landmark case. All these are landmark cases. Say that courts must provide due process in transferring juveniles to adult court. In other words, there must be some form of hearing. It's not done without going through the process. And even, you know, with those waiver systems, there's still some form of due process that takes place where the juvenile is given the opportunity to be able to, through their attorneys, provide a legal defense to the charges that are brought forth in the petition against them. So then in 1967, the In re Galt case is a hearing that said that before you can commit a juvenile to a institution, as I was saying earlier, then there are 4 basic constitutional rights. The right to timely notification of the charges. These are basic due process rights. The right to confront and those witnesses. The right against self-incrimination. In other words, they don't have to testify. The 5th Amendment, applicable through the 14th Amendment to the states, applies to juvenile as it does in criminal court. And the 6th Amendment right to counsel. As you know, the 6th Amendment right was given in Gideon versus Wainwright and Escobedo versus Illinois extended, and that if you are going to be incarcerated, or should I say your liberty taken away, or you're going to be detained in custody, then you have a right to counsel. And so juveniles under the 6th Amendment have that same constitutional right based on what In re Galt provided and stands for. Then in 1970, In re Winship, it was determined that the state has to use the same standard as we use in the adult criminal court, and that is the standard of beyond a reasonable doubt. As you know, in the civil courts, it's preponderance of the evidence. But in a criminal court, an individual, before they can be sentenced or found guilty by a judge or a jury, the standard or the level has to be proof beyond a reasonable doubt that that person is guilty of that offense. All right. So, and in a minute, I'm going to talk about this. Is that in 1971, since it was determined that they have all those rights, one of the questions that was still under debate was whether or not juveniles were entitled to have juries. And the Supreme Court clearly in McKeever versus Pennsylvania made it clear that juvenile trials are not constitutionally required. Jury trials are not constitutionally required in juvenile court proceedings, and the reason is because of the fact that, remember, who has control, who determines the innocent or delinquency of the individual juvenile is the judge. And if you put the jury system in, then you're removing the control that the judges have for juvenile. Because, as I said earlier, the purpose and direction for juvenile justice is more rehabilitation. Should be in adults too, but the primary goal is to rehabilitate rather than straight up to incarcerate. So that's what. So the juvenile jury trial would take and include 6 to 12 individuals who are not judges. And so at this point, and I can't see it changing, because since 71, that has been the standard. Now, that's while it's in juvenile court. Now, once it is transferred to adult court, then that constitutional right is going to stick in. All right? So then we come to 75. This is the year that I started law school. In the Breed versus Jones, dealing with the waiver of a juvenile to criminal court, if you deal with that, you cannot try, if you try a juvenile in juvenile court, you cannot waiver them to criminal court. So that makes sense. It's double jeopardy, because what you then do is give the prosecutor the chance to try to find the individual delinquent, and then if they're not successful at that, then they can transfer it to adult court and then find the individual guilty in that. But that would be tantamount to trying the individual twice for the same offense, which is double jeopardy. And so double jeopardy applies to juveniles as of 75. And then in 79, the year after I got out of law school, this case involved Smith versus Daily Mail Publishing Company. Says that the press may report juvenile court proceedings in certain circumstances. So that prior to that, the press was totally let out. But remember, I said that there are really some serious restrictions that the press does. Like, for example, the press can't use the name of the juvenile and those kinds of things in their reporting. Because of the fact that, and if cameras were allowed in the courtroom, then they're going to be blotting out the individuals. But I don't think at this particular point that there are any juvenile courts that allow cameras in the courtroom, because again, that would change the process away from the goal of what juvenile justice is intended to accomplish. Moving right along, in 1982, in Eddings versus Oklahoma, the decision was that a defendant's youthful age is considered a mitigating factor to determine whether or not to apply the death penalty. Now, this is historical information I'm giving you, okay? So actually, this is not going to be the way we're going to end up when we get to 2005, because there is a landmark case that even changed all of this and made it cut dry. Because what happened is that the death penalty was still being considered in some jurisdictions based upon the offenses that a juvenile committed. And the definition of juvenile in most jurisdictions is 17 and under. So, there were variations. So finally in 84, well, we're going to go to 88 in a minute. Before we get there, Shaw versus Martin, preventative pretrial detention of juvenile is allowed under certain circumstances. The same thing as in the adult court. Bail is the person is not necessarily allowed to leave, depending on the offenses, if they're serious, if they're flight risk, and things of that nature. There is no bail in the juvenile court at all, but preventive detention is allowed under circumstances where an individual finds himself in that situation. 88. This is when the age for the death penalty is set at 16 in Thompson versus Oklahoma. Now, and so therefore, it reached a point that if a person committed a crime and they're under 16, then they couldn't be subjected to the death penalty. However, that stayed for a number of years until we get to 2005, which the final landmark case, which is Roper versus Simmons. And if you don't know about it now, you'll learn about it in the criminal law class that you take, Introduction to Criminal Law, said that the minimum age once and for all is set at 18. And so what happened is, the reason this occurred is because states were split on the age determination for the death penalty, and also it was still argued that when a crime is committed, and it has to be at the age at the time of the offense, not the time of the sentence, but the time of the offense if the person was 17 years old and had not attained 18 years old when the offense was committed. In that case, the most you could give them is natural life. And I had a situation like that when I was near the end of my career. Of course, it was before Roper versus Simmons, but Illinois had pretty much decided even before that that 17 was the protection for juveniles, and that if you committed an offense 18 and over, then it was the type of crime that qualified for the death penalty, then you could end up getting that. Of course, as I speak now, Illinois does not have a death penalty because it was done away with, okay? Because as you probably already know, and you will discover that the death penalty per se is not a unconstitutional issue. It's not cruel, unusual punishment. The famous case, I think it came out in '72, I believe it was, Furman versus Georgia, which indicated the steps that are necessary before a person is executed. And you should be aware that there's a long time between the time a person is placed on death row and they're actually executed, if they are executed at all. So anyway, the main point here is that minors are protected when it comes to dealing with the death penalty. So there is no death penalty for them. So now there's certain terminology that you need to be familiar with, and this is beneficial as far as preparing for the quiz. And these definitions, we talked about some of them. So parents patriae, what is that? And here it is. It is a Latin term where the English kings established the right to intervene in the lives of children in their monarch. And so who steps in as parents patriae today? The judge, the juvenile judge. Okay. Next. Juvenile delinquent. This is a person who has been a minor who violated criminal law, or they're truant or a runaway, and so they've been determined to be delinquent. And remember, I said that that's the adjudication. You're found not to be guilty, but delinquent. Next, status offender. What's a status offender? A juvenile who engaged in behavior that is illegal because of their age. In other words, their status. That is what creates the actual status offender. So again, as I said, if a person is under age of 18, there are certain things that they cannot, certain sentences or adjudications that won't happen. What is community treatment? The title kind of explains it, to provide the protection services necessary to help the juvenile, and probation and counseling and restitution is necessary. That's what is called community treatment. Institutional treatment is the other, where facilities operated by the state or county to restrict the movement of residents through staff monitoring, locked exits, and interior fence controls. That's how you might find some very incorrigible young people who are eventually probably going to end up in adult prisons. Residential programs is where placement is used by the juvenile probation officers, or while they're in facilities, such as placing them in group homes, family group homes, wilderness programs, boot camps. these are things that are programs that are designed to try to turn that individual away, to get them to understand the seriousness of their offenses and go in a new direction. There's also some types of what they call scared straight programs, which I was familiar with, where individuals are placed in situations where they understand, well, they learn about how bad it really is where they're heading, and it's an attempt to try to scare them into straightening up as well. So those residential programs. Non-residential programs is where they're not confined overnight. We're the same kind of programs, but they're not confined overnight. Aftercare is like parole. And what happens is, after the individual is released and still on what we call paper, they then will have to, of course, report again to the parole officer. No, probation officer is who actually will handle them in that situation. Judicial waiver, we talked about that, is an intake personnel where prosecutors or judges make a decision whether to try the juvenile in adult court. Again, there are statutes based upon the various jurisdictions, systems that you will be discovering when you conduct your research based upon the jurisdiction that you're in, as to how juveniles find themselves in adult courts. Be aware of the fact that the offenses that are more serious land juveniles in adult courts. Social investigation report, that's the same as what we call a PSI, and where you determine the background and history of a juvenile, the same thing as the pre-sentence investigation in adult court. And it's utilized to determine how long the person is there, what type of things that are needed for the juvenile as well. So it's called a social investigation report. Because remember, you're not sentenced, you're adjudicated, so it's social investigation report. Statutory exclusion. What that means is that some states automatically transfer juveniles to adult court for certain offenses. Now, those have been, of course, though, you have to remember that there's still some due process built into that as well, so that the individual then has a chance to provide an opportunity for these for the judge or for the not to transfer these juvenile offenders into adult court. But it actually helps the judge to determine whether or not to send those individuals to juvenile court. And that's the end of that. And I hope that you've clear understanding about how the juvenile justice system operates. So now, before I adjourn, I want to spend some time talking about next week. Since there is no lecture next week, the future of corrections and what direction corrections are going, you can have a chance to look at this content itself, dealing with terrorists, dealing with technology, and how it has changed or affected. You'll have a written assignment to that effect. As a matter of fact, we're going to go to that right now. These are the assignments that are due for the final week, which will be due on the 13th. So your written assignment dealing with technology in your correctional system, and conduct an internet search, to find the latest technological tools available to correctional professionals. And in a 1 to 2 page paper, with it's going to be APA because you're going to go look at the rubric, and it tells you what the requirements are, what you have to do, conduct some research, paragraphs, 1 to 2 page minimum, and then this standard APA citation and overall format is also applicable as well. So don't tell me, says, oh, it doesn't say APA in this. It does in the rubric, and that's the key thing. All right. As I have said time and time again, the module and the rubric really work hand in hand, but the rubric gives specifics and expectations about how I'm going to grade your papers, and that's what you need to use as your final determination. And then your discussion posts that are due. Your initial post will be due that Tuesday, which will be September the 10th, and then your reply post will be due that Friday the 13th. And then finally, your final exam, 40 multiple choice questions. There's a timed exam. And how's the best way to prepare for this? You can go back and look at the PowerPoints for the course, and keep in mind that you should make sure that you have completed the assignments. And if you've completed the assignments, done the reading, and actually listened to the lectures, you can probably do well in this. So it's 40 minutes, and it contains 40 multiple choice questions. So you know exactly how long it's going to take. And that's it for this particular course. And so I hope that you have learned something about this course. I hope that you understood the course project. I tried to give you from day one the requirements for it. Some of you got them and some of you didn't. Your organization for your week 9 assignment, which I'll be grading, involving your final project. I hope you followed what I shared with you earlier about that. And I just wanted to let you know that it's been a pleasure. I am told that I don't know if it's going to be in the next quarter, which I don't think so. It won't be, because I've already received details that I'll be teaching this course again. Hope I don't see any of you in that course. What that means is that you didn't complete the course or that you failed the course. But I want to say to you that I hope I see you in other classes. Many of you will find yourselves with me in criminal law next quarter, and then you will have me in drugs and crimes, and then I run into many of you at the end when you take contemporary issues in criminal justice. And be aware of the fact that these 11-week courses are being filtered out and reduced to 5.5, and I'm happy about that because of the fact that it's a challenge for me, even as a professor, to have these 11-week classes along with the 5.5. So, because like right now with the second portion, I'm teaching actually drugs and crime, introduction to criminal law, contemporary issues in criminal justice, and this corrections course since the beginning of the contemporary issues and the introduction to corrections for the last 10 weeks. So anyway, that's it for me. I hope that again that you will heed the things that I've shared with you. I hope I see you further down the road and in other classes. And I'm going to say good night at this point.